Welcome back to the channel. Today's case moves fast, and it's messy. We're in Georgia, where Britney Harris stands charged with disorderly conduct tied to an incident outside the world's busiest airport. Atlanta's Hartsfield-Jackson. The charge sounds simple, but the context isn't. Airport security rules, public space behavior, minors present, and what police call combative conduct during detention. Right out the gate, we'll see a guilty plea. But watch how the judge works through constitutional rights, immigration warnings, and a factual basis before accepting it. Defense will push for 60 days instead of the state's 90 days, while the judge weighs not just punishment but real-world safety, mental state, and whether keeping the jail less crowded makes sense when someone might stabilize outside custody. We'll also hit a behind-the-scenes wrinkle. Was this plea negotiated or not? The prosecutor wants clarity. The defense says it was always non-negotiated. That matters because it affects expectations and credibility in the courtroom. As you watch, ask yourself, does yelling in a smoking area cross the legal line into disorderly conduct, or is this a heavy-handed response to a volatile moment? And if someone's less altered now than they were at arrest, should that shorten jail time? Buckle up. Lots of moving parts, and the judge's final call might surprise you.
All right, raise your right hand for me, Ms. Harris. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Speak up and say yes.
Yes.
All right, you can put your hand down. Ms. Harris, you're before the court for State of Georgia versus Britney Harris 2025 CR.
This is the foundation of any plea. The judge is making sure Britney understands what a guilty plea forfeits presumption of innocence, the right to confront and subpoena witnesses, the right to remain silent, and, for non-citizens, the potential immigration impact. Courts do this to prevent appeals later claiming, I didn't know what I was giving up. Notice how the judge slows Britney down when she tries to jump in first the facts, then the objections. That sequence matters. The court needs the record to reflect that the plea is knowing, voluntary, and intelligent. Quick engagement question, if you were pleading guilty to a misdemeanor to get out sooner, would you still push back on facts? You dispute or save it for sentencing? Sound off below.
00268 for disorderly conduct. Mr. Lynch, what is your client plead to the offense of disorderly conduct?
Judge, she pleads guilty.
You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, ma'am?
Yes, Your Honor. Your Honor, can I ask you this? Really, I didn't do nothing.
Hold on. The best thing to do is to talk to your attorney, but let me get through the factual basis, and then once I hear the facts, then I can hear whether you disagree with them or not. Okay.
Okay, ma'am.
All right. Thank you. Just that way I'll know what you're talking about. Okay. All right. Go ahead.
Here comes the state's narrative. Officer dispatched to the airport's smoking area. Loud screaming, verbal intimidation, cursing in front of minors, refusal to stop, and then physical resistance during detention. In plain terms, disorderly conduct isn't about being annoying. It's about conduct that disturbs the peace or provokes fear. The minor factor ups the stakes. Courts treat profanity around kids at public transit hubs more seriously. But pay attention to precision. Combative can mean anything from pulling away to outright striking. The defense will likely frame this as over-policing an outdoor space. Question for you. Where's your line between free expression and disorderly conduct? Volume, profanity, proximity to kids, or physical escalation?
Factual basis recommendation, please.
Yes, Your Honor. On or about December 19th of 2024, Officer F as in Frank, last name Shelley, was dispatched to 6000 North Terminal Parkway, also known as the Atlanta Hartsfield-Jackson International Airport, in reference to a disorderly female. Upon arrival, the defendant was sitting outside door N3 in the smoking area, screaming, verbally intimidating passengers and cursing in the presence of minors. Officer Shelley at that time approached the defendant and gave her an opportunity to calm down and cease the cursing. However, the defendant refused, and she continued cursing and screaming, and she physically became combative when Officer Shelley attempted to detain her. At that time, the defendant was arrested and charged with disorderly conduct. Your Honor, the state's recommendation is 12 months to serve, 90 days balance suspended, and the defendant can get credit since the day of lockup.
The state recommends 90 days and a 12-month sentence, the rest suspended. Defense counters with 60 days as adequate. Translation: both sides agree jail time is on the table. They're fighting about how much. Adequacy turns on deterrence, public safety, and proportionality. If the incident involved escalation with police at a high-security venue, prosecutors argue the higher number deters repeat behavior near critical infrastructure. Defense, meanwhile, signals remorse and stabilization, pushing for a shorter cap. For you, does 30 days make a real difference? Error is the bigger impact. What follows? Like stay-away conditions from the airport without a ticket.
Okay, well, let me ask you this, Your
Before you
Honor.
speak, can I just say something quick? So Judge, we had, and if Ms. Harris wants to speak, I'll certainly give her that opportunity. But I had previously spoken to Ms. Harris about this case, and I was going to ask the court to sentence her rather than the 90 days that the state's recommending. We feel that 60 days would be
Boy, this
more
order
than adequate.
Really,
Man, hold on a
you
second.
envious of me, man, possessed with it. The Lord keep telling y'all so possessed with envy.
Man.
Yeah, I'm not the Lord. It's nothing that beautiful for his eyesight, man.
The hell? All right, I'm gonna need whoever said the expletive to mute your device.
Your Honor, can I explain to you?
Now we hear Britney. She says she was outside, smoking, harassed, and then grabbed, framing herself as the target, not the aggressor. This is a crucial narrative pivot. A defendant can plead guilty yet still explain context to mitigate. Judges, listen for ownership versus minimization. Does she take responsibility for the disruption or place it entirely on officers? The judge tests specifics. Were you outside? Were you traveling? Those answers matter because airport policy often treats loitering differently than active travel. Engagement moment. If you felt wrongly confronted by police, would you stay calm to preserve your case, or would stress take over in the moment? Be honest.
They keep harassing me. I'm smoking outside. What have I, why
Okay,
am I
Ms. Harris, let me ask you a question. Were you smoking outside the airport?
Yes.
Okay,
And harassing me all the time.
so you weren't in the airport, you were
No,
smoking
I was
out.
not. I was outside smoking.
Okay,
She come grabbing me. Come on, what am I doing? I'm smoking.
okay. Have they done this before? Okay, let me just ask you this, Ms. Harris. Were you traveling that day? Did they delay your travel at all?
Yes, I was finna get on the plane.
Where were we
Go
going, Ms. Harris?
home. I'm from Birmingham. I was about to go home.
Okay,
They harassing
so
me all the time.
Ms. Harris, I get that. My understanding is they have really shut down the airport. They have cut it down to where it.
She lying on. I'm talking to her. Can I talk? I have no rights in this world, man.
I'm sorry.
Ms. Harris, I'm listening to you. It's okay, Whitson. Ms. Harris, just listen to me. So they have some new rules about.
This is key. The judge explains tightened airport rules whether you're inside, outside, or on MARTA. If you're at the airport, you may be asked to show a same-day ticket. Why airports are sensitive security zones. Policy aims to limit congregating, especially in areas where passenger movement and safety are priorities. Even if you're in a public smoking area, failing to comply with lawful instructions or creating a sign can trigger enforcement. The judge's tone is informational, not accusatory. She's putting Britney on notice for the future. Question: should large transportation hubs apply stricter behavior standards than a normal sidewalk, or should the same public space rules apply everywhere?
Out the airport, and they have really like slapped down on people being at the airport. Now the rule is if you don't have a ticket that you can show them, whether you're outside the airport, inside the airport, or on MARTA, if you at the airport, yeah, if you don't,
Plays all down there.
man, it is bad. If you don't have a ticket to show them that you
Never
are
asked me.
flying,
They
didn't ask
no one else. Everybody out there smoking.
I got you. I got you.
We learned Britney has been in custody since December 19th. That time matters. Credit for time served can make a shorter sentence functionally complete. The judge probes a practical issue. Does Britney have somewhere to go that isn't the airport? This is more than kindness. It's risk management. Courts weigh whether releasing someone will reduce or repeat the very behavior that led to arrest. A stable destination suggests lower recidivism risk. Engagement question: if the court is balancing punishment with public safety, does some place to go matter more than the exact number of days left?
And
All right.
Your Honor, I'm in my room. They never let me out.
How long has she been in?
They let
So
everybody
that's December 19th.
Ms. Harris, let me ask you this. If I let you out, do you have some place to go that is not
Yes,
the
ma'am.
airport?
Yes, ma'am. I would never attend there no more, Your Honor, I promise.
Okay. All right. So Miss
Here's the ruling: 12 months, 60 days to serve, balance suspended, plus a stay away from the airport unless Britney has a same-day ticket. That condition is targeted. It doesn't ban travel. It bans loitering or return to a hotspot without legitimate purpose. Courts like focused conditions, clear, enforceable, tied to the conduct. From a legal craft perspective, this is smart. It mitigates risk where the incident occurred while still allowing normal life. For viewers, is a stay away order more effective than piling on extra jail days? Many judges think so when the problem is location specific.
Harris, I'm going to cut it down to 60 days and credit since the date of lockup. So I'll accept your plea, 12 months to serve 60 days. Balance will be suspended.
Really? I'm supposed to sign out. This is my first offense.
Hold on. As long as you, okay, now listen, but as long as you do not go back to Hartsfield, Jackson, Atlanta International Airport, unless you can actually show a ticket for a flight on that day. You understand?
Yes, ma'am.
All right. You can go back with the sheriff's office.
Okay, well, can I ask you this?
Yes, ma'am.
Tell them to let me out.
Britney asks, what is credit? Great teaching moment. Jail credit equals the days you've already spent in custody on this case. It counts toward your sentence. The judge estimates about 1 to 2 more weeks left. This transparency matters. It helps defendants plan, reduces chaos at release, and avoids the perception that the process is arbitrary. It also signals the judge's intent. Punish, but don't warehouse when the person might be stabilizing. Audience question: if someone has already served most of their time by sentencing day, should the court tip toward finishing the case quickly or extend the tail to reinforce deterrence?
They not letting me out. They letting others out.
They won't let you out of your cell.
Going home for these.
Well, I think you might have enough credit for that almost.
What you mean credit? What is credit?
Credit since the date you got locked up. I think you'll be let out soon.
What is soon?
Let's see, the 19th. You got about a week and a half, maybe 2 weeks.
2 weeks. Okay.
Yeah.
Thank you.
All right. And you'll be through the snowstorm. That way you won't have to be outside in the snow, okay?
Ma'am, you have a nice one, Your Honor.
You too, Miss Harris. Thank you so much. You take care.
Your Honor, may I just address something?
Enter Ms. Ponder for the state, raising a procedural concern. Don't label a plea negotiated unless it really is. This isn't nitpicking. When a plea is negotiated, both sides expect the court to adopt or at least weigh the deal heavily. In a non-negotiated plea, the judge has full latitude. Defense responds forcefully. They never said it was negotiated. The judge neutralizes the friction. Label it clearly up front next time. Professional takeaway: records matter. Precision about plea posture preserves trust and prevents accusations of sandbagging. Engagement: do you think this was simple miscommunication? Strategic positioning after an unexpected 60-day outcome.
Really quickly.
Yes, ma'am, Ms. Ponder. Go ahead and put on the record.
Okay, thank you, Your Honor. So I just would like to bring it to the court's attention. So initially, when we did do negotiations, I went down to the courtroom to speak with Mr. Lynch and Mr. Taylor to make sure that we were ready to go for the court once you were on the bench. I know that the court has the final say-so during sentencing. I think my biggest issue is that counsel had indicated that this was a negotiated plea. Then once we actually speak.
At no point did I indicate Ms. Harris was in the.
I'm sorry, Mr. Lynch. I will not interrupt you, so may you not interrupt me, please.
Please don't make false statements to the court.
Okay. So my biggest issue is that when we do negotiated pleas with counsel, it is not until the court acts, and then at that point it is as if it is non-negotiated. So I would just ask in the future for counsel to indicate whether or not this is negotiated or non-negotiated prior.
Can I please respond? So I understand what Ms. Ponder is indicating, and I have no problem doing that. However, it is blatantly false. At no point did I state that Ms. Harris was going to be a negotiated plea. I had determined it was going to be a non-negotiated plea when I first indicated her. So if Ms. Ponder is stating,
Yeah, but usually you say, Judge, this is non-negotiated, and I didn't hear that at the end of.
sure, but Ms. Ponder
I
stated
get it.
I said it was negotiated, which I did not. And I
Okay,
did not
but she
appreciate
might
it.
have been under the same impression that I was, that usually if it's non-negotiated, you will say that. That's neither here nor there. I understand that if y'all negotiate something, then both sides want to rely on the fact that it's been negotiated. I don't have a problem. The issue that I have.
Listen closely. The judge notes Britney seems less altered, now likely referring to agitation, intoxication, or mental health presentation, and suggests she may stabilize better outside than inside, if released sooner. The judge also mentions a broader jail management goal, reserving scarce resources for those who truly need high monitoring, while moving low-risk defendants out with targeted conditions. This is a modern, pragmatic sentencing philosophy. Tailor punishment, reduce churn, and try to stop the cycle that sends people back for the same location-based friction. Question: is this smart triage or soft justice? Your call. Drop your reasoning in the comments.
Have with Ms. Harris is she seems to not be altered significantly right now. I think it could get worse, but if she has the ability to get to stability while she's not altered, I'm hoping that that'll be now as opposed to waiting the additional 30 days. And that was my only concern, is that I think that at this point, she's less altered than she could be. And when she is less altered, it is a possibility that she could actually make her way to someplace that is not the airport for security purposes or for safety purposes. I'm hoping that will happen, but Ms. Harris will probably be back before me, and I anticipate that. And I get where you're coming from, Ms. Ponder. I'm just trying to, I guess, lessen the number of people who are going to be in the jail and require a higher level of monitoring, as opposed to individuals who I know can handle themselves in the jail. That's it. I'm just trying to balance it a little bit, but I get what you're saying, and your point is well taken.
Thank you.
Who's next? Go ahead.
Well, I just wanted to make one.
Mr. Lynch, I'm not saying that there's anything wrong with you. I'm just saying that if you all negotiate. Then if you don't, it's non-negotiated. Indicate that, and I'll go both ways.
And I'm totally fine with that. When Ms. Ponder came down here, she asked what case we need to go over, and we discussed all the cases that we were going to negotiate, and then we talked about those cases. At no point did Ms. Harris's name come up one way or the other. And so if I was going to negotiate, I didn't say this was going to be a negotiated plea. I didn't say that to Ms. Hagler. I didn't say that to Ms. Ponder. And so I just, I understand if she wants us to say at the first if this is going to be negotiated or non-negotiated, but she didn't ask. And so it's just a little disturbing to me to have a statement that I made a statement that this was going to be negotiated when I made no such statement. And I that's all I'll say.
Okay, well, your point is well taken too. Who is next?
I'm sorry, Your Honor, again.
I thought it was a petition.
It is a petition.
It is, Your Honor.
Okay. Hi, Ms. Carmichael.
Good morning to you, Your Honor.
One second. Who is yelling?
That's Ms. Harris, Your Honor.
Okay.
The deputies are taking care of her as soon as they're available. We'll have Mr. Jackson brought out.
Oh, she's quite loud. Yeah, 90 days in the jail. I don't know if that'll help or hurt. Oh my goodness. It's hard to make that determination at this point. All right, so this is
Britney Harris pled guilty to disorderly conduct stemming from an incident at the airport's smoking area, involving loud profanity around minors and resistance during detention. The state asked for 90 days. Defense persuaded the court to set 60 days with time served credit and a stay away from Hartsfield Jackson unless Britney has a same-day ticket. A side dispute over negotiated versus non-negotiated pleas ended with the judge urging clearer labels in future. The judge's reasoning emphasized public safety, behavioral stabilization, and jail resource management, not just raw punishment. Takeaway: in high-security spaces like airports, conduct standards are tighter. Targeted conditions can matter more than extra jail days. If you found this case as shocking as we did, hit like, drop your take in the comments. Was 60 days fair? And subscribe for more jaw-dropping courtroom breakdowns. Share this video with someone who loves real-world law in action.